All rise. Yes.
Good morning, my lords and the lady. With my learned junior, Miss Eleanor Harris, I appear on behalf of Mrs. Agbaje, the appellant. My learned friend, Mr. Timothy Scott, Queen's Counsel, and Mr. Peter Mitchell appear on behalf of Mr. Agbaje, the respondent to the appeal. If I may, I will adopt the family law convention of calling the parties husband and wife. The principal issue arising on this appeal is in what circumstances is it appropriate for the English court to make a further financial order when a foreign court has already divorced the spouses and made a financial order. At first blush, it may seem unusual that courts in two different countries can, at different times, make financial orders arising out of the same cause of action, namely the parties' divorce. The power in the English court to make a further financial order derives from Part 3 of the Matrimonial and Family Proceedings Act 1984, and it was intended by its framers, the law commissioners, to remit financial hardship arising from two distinct circumstances.
I suppose I should make it absolutely plain that this is the work of my predecessor at the Law Commission. I had no hand in Part 3 at all.
Yes, we saw the authors listed in the report. The two circumstances that the Law Commissioners were addressing were these. Firstly, when a foreign court had made no financial order at all, and secondly, where the foreign court had made a financial order, but that order was inadequate. And this appeal is concerned only with the second category. It is a condition precedent to the exercise of powers under Part 3 that the wife has to show, in the circumstances of her case, that a serious injustice has arisen. The serious injustice that this wife relies upon is that after a marriage of 32 years, which produced 5 children of the family, and where the assets were around £700,000, the Nigerian court in June of 2005 awarded her a lump sum of £21,000 and a life interest in a house on Tin Can Island in Lagos. This very modest award produced a very significant disparity or discrepancy in the allocation of the assets between the parties. The wife was left in a position in which she did not own any one of the 4 properties in the case, 2 of which were in Lagos and 2 of which were in London. She was only left with a life interest in a property that had ceased to be her main home in 1999, 6 years before the Nigerian court had made its order. In 1999, when the marriage broke down, she came to London to live at 27 Lytton Road in New Barnet, a property which the husband had owned from 1975 and which had thereafter been used as a base for the family during the marriage. The trial judge, Mr. Justice Coleridge, found that these parties had a long-standing and enduring connection with this jurisdiction. And on the basis that the wife forfeited her life interest in Tin Can Island property in her husband's favour, he made the following order under Part 3. He ordered that Lytton Road be sold and that the wife receive 65% of the net proceeds of sale, which was intended on the valuation used in the proceedings to give her about £275,000, which was to be used as follows: £225,000 to buy herself a modest flat in North London, and £50,000 as a cash sum to supplement her income when she is unable to work. The wife is now aged 69. The Court of Appeal allowed the husband's appeal and dismissed the order for financial provision in toto. As a consequence, the wife will be homeless in this country, where she has been a citizen since 1972, and where she has made her home and worked as a carer for the last 10 years. The purpose of Part 3 was to remit hardship arising from the order of a foreign court. Yet the Court of Appeal have provided an outcome which Lord Justice Ward, who gave the lead judgment, candidly admitted has left the wife in a parlous plight. In making my submissions, my lords and my lady, I want to address 5 topics. The first will be the policy issues considered by the law commissioners, which are material to this appeal. Secondly, the statutory provisions of Part 3.
Mr. Dyer, you said when you began that it was a condition precedent
Yes.
of the exercise of these powers that a serious injustice would
Yes.
otherwise occur. Does that appear in the statutory provisions?
No, it appears in the report.
Yes, but it's not in the statute, is it?
No, it's not.
No.
It's not. No, quite so. In fact, as I'll develop in due course, the language in the statute does not express such a hard test to satisfy as the law commissioners said they wanted to provide for. It's a somewhat unusual feature of the statute, although subsequent cases, particularly of the Court of Appeal, have construed it very restrictively. The third matter I would like to address is how Part 3 should be applied. Fourthly, why the Court of Appeal was wrong, which will incorporate responding to Learned Friend's printed case, as he is seeking to rely on the judgment of the Court of Appeal. And finally, I would like to conclude briefly with why the appeal should be allowed. So if I may start with the policy issues considered by the law commissioners, could I ask you please to take Authorities Bundle Volume 1, where you will find the Law Commission report behind tab 1. Tab 1 comprises of the Commissioner's report, which is quite short, followed by a draft bill, which became Part 3, and then at page 75, the working paper. And the working paper is the main body of the Law Commissioner's work, and the recommendations that it made were accepted by the Law Commissioners in their report. And as a result of that, they framed the draft bill, which was incorporated into Part 3.
Was it incorporated unamended, or was there any change?
Yes.
It was.
Yes, it was. There are a few things that are different. The layout is different, but no material changes.
Change.
No. If I could just refer you, please, to the very first paragraph, just to set the background as to why the Law Commissioners were involved. And they succinctly state in paragraph 1.1, where a marriage is terminated by foreign proceedings in which no financial order is made, a court in this country has no power to grant financial relief. In recent years, there has been a steady stream of cases coming before the courts, which has both highlighted the gap in the law and illustrated the hardship to which it may give rise. The view is that the law is in need of reform has been widely expressed. The obvious case, or what was known as the paradigm case for reform, was where the foreign jurisdiction had made no order at all in favour of invariably the wife applicant. But there were other cases which caused the Law Commissioners some concern, because there were cases where a spouse had either not made an application for financial relief in the foreign court, even though she could have done so, or, as in this case, she had made an application to the foreign court and obtained an order which she perceived as being inadequate. And this was a matter that the Law Commissioners considered. And if I could ask you, please, to turn to page 91 in the working paper, paragraph 27, they pose the specific question, should there be a bar in cases where the foreign court has or could have made an order? The difficulties in the way of reform of the law are thus formidable. They are most acute in cases in which the wife could have applied for financial relief in the country where the divorce was granted, but either failed to do so or did so but obtained an order which she regards as inadequate. Correspondingly, the difficulties are least acute in cases where the law of the country where the divorce was granted contained no provision for financial relief in favour of the wife. We think there is little doubt that a wife who is thus unable to obtain any financial relief should, provided she can establish a sufficient link between the marriage and this country, be eligible to apply for a financial order here. But we have had to consider carefully whether the power we propose for the English court to hear applications for financial relief, notwithstanding the existence of a prior foreign decree of divorce, should be exercisable only in such cases and not in cases where the foreign court had made or could have made a financial order. We are, however, in no doubt that such a rigid restriction would be inappropriate. Our primary reason is that, as we have seen, the country in which the divorce was granted may well not be one with which the marriage has much real connection. But there are also subsidiary arguments which seem to us to support the view that a restriction of this kind would be undesirable. First, injustice could occur if the foreign divorce court, having dealt with part of a wife's claim for financial relief, could not or would not make any order in relation to capital assets in England, and the English court were precluded from making any order because of the foreign court's order. And my lord and lady, we say that that really strikes at the very heart of this appeal, because in the Nigerian court, the position was that they could not make an order to transfer Lytton Road to the wife, and nor would they make any order for her to have a settlement of that property either. And as you will see when we go on to look at the statute, the Law Commissioner's view that there should be no restriction was actually enshrined in the statute, specifically in section 13.2, where the statute says that you can make an application, notwithstanding that the foreign court has made an order for financial provision. The foundation of Part 3 was based on the Law Commissioner's view that a foreign court which had granted the divorce was not necessarily the only court to deal with all issues arising from the divorce. And they came to this decision for two reasons. First, they recognized the increasing international mobility, which meant that a marriage and the spouses can have connections with more than one jurisdiction and one legal system, where they married, where they're domiciled, where they are nationals, and where they have lived during the marriage, pre and post separation, and where their assets are located, give them a connection with more than one jurisdiction. And if I could ask you, please, to look at paragraph 27, which is the preceding paragraph to the one that I've just referred to. And just starting from the second sentence, it reads, "In a world of pure legal analysis, it would no doubt be possible to identify a single system of law with which the marriage was more closely connected than any other. That system could then be regarded as the proper law of the marriage. As such, it would govern the marriage and its consequences. We do not, however, think that this aim can in practice be achieved. At a time when people can travel easily from one country to another, marriages are increasingly connected with several different systems of law. For example, with the law of the party's nationality, or the law of their place of residence, the place where the marriage was celebrated, or even with the law of their religion. In our view, it is unrealistic to suppose that a process of juristic analysis will identify any single right system of law to which all questions relevant to a particular marriage should be referred to the exclusion of all other systems. Now, in this particular case, although it is right to say that during the marriage the parties spent most of their married life in Nigeria, they have a long-standing and enduring connection with this country. This case is a very good example, we say, of the sort of category of case that the law commissioners were considering in paragraph 27. There is no right or obvious jurisdiction to resolve all matters that arise in this case. And it's interesting perhaps to make the point that both parties had jurisdiction to issue a petition for divorce in Nigeria and in England. That shows the connection. It is difficult, when you look at the background to the case, which I'll come to in a bit in more detail in a moment, it's difficult to identify any aspect of the parties' lives that did not have a connection with England from the very beginning. They met here, married here, and the husband still owns 2 properties here. They're dual nationals, and perhaps the most striking feature of the case from a financial point of view is that 75% of the parties' wealth is not in Nigeria, but it's in England. The second reason for the Law Commissioners rejecting the principle that only one court should decide all financial matters consequent on divorce was that the Commissioners recognised that an injustice could arise when the foreign court had made an order which was inadequate and produced a serious injustice. This inadequacy could arise in a number of different ways. First, the foreign court might not have extensive powers to make financial orders. It might be only able to make orders for maintenance as opposed to orders for lump sum or, as we have in this country, property adjustment. Secondly, the foreign court might not have the power to make orders in respect of property, especially immovable property outside its territorial jurisdiction. This meant that a property in England would be outside the ambit, or could be outside the ambit, of a foreign order. And also, lastly, and of significance in this particular case, is that foreign courts do not necessarily have the range of orders that courts can exercise in this country. The range of orders might be very limited, as was the position here, where the Nigerian court, it is common ground, only has power to order a settlement of property and not an order for property adjustment, which transfers the ownership of property from one spouse to another. Also underlying the Act was the Law Commissioner's concern about the financial burden that could be thrust on the public purse if the effect of the foreign order made inadequate provision. And that is referred to not only in the report, but also in the working paper. If I could just ask you, please, to turn back in tab 1 to page 2. It's the second page of the Commissioner's report. They were dealing with a situation where no order had been made by the foreign court. I'm just reading 4 lines down from the top of page 2. Such a woman may thus face destitution, and her only source of financial support may be supplementary benefit. And if benefit is paid to her, the supplementary benefits authorities will have no legal right to recover the sums paid from the husband, since he will no longer be a, quote, liable relative. The fact that the husband lives in this country and has substantial assets here makes no difference to the legal position. And that concern about being a drain on the public purse is also a factor in this case, because as a result of the Court of Appeal decision, the wife has been deprived of the means to provide a modest property for herself, and if she wants to remain living in London, where she's lived for the last 10 years, she will have to apply for local authority housing. And I will develop this point in due course.
Are any of the other members of the family in this country?
Yes, my lord. Yes. There are 5 children of the family. The youngest child is living in New York. The 4 eldest children all have properties in London.
They live here?
2 of them work here, one of them works in America and is occasionally here, and the other one works in Nigeria. So in principle, the law commissioners considered that a dual adjudication in different countries was permissible. But in giving a remedy in this country, the commissioners were concerned about forum shopping, because that was something that they wanted to discourage. And if I could ask you please to turn on to page 89, they gave a definition of forum shopping. Paragraph 22, please, about halfway down the page. It says, in our view, the advantage of giving a remedy needs to be very carefully balanced, not only against the risks of forum shopping, that is, the risk that litigants with little or no real connection with this country would start proceedings here solely because they would be likely to find it financially advantageous to do so, but also against the related risk that to confer such a power on the courts could, in the absence of any clear guidance on what law should apply to the incidents of a particular marriage, pose problems which it would be difficult, if not impossible, for them to resolve. Well, we don't need to be concerned about the applicable law in the case because English law is applied, and in Scotland, Scots law is applied. In order to meet their concerns about forum shopping, the law commissioners proposed 3 specific safeguards. The first were jurisdictional requirements based on those for divorce proceedings. They considered that the parties should, or either of the parties should be domiciled in England, Wales, at the time the application was made or when the foreign divorce order was made, or alternatively, both parties could be, or sorry, either of the parties could be habitually resident in this jurisdiction for a period of 12 months, either before the application was made or the foreign divorce took effect. There is also another basis for jurisdiction, which doesn't apply in this case, but I'll mention it anyway, because the wife could have come within this provision had she wanted to. And that provision is that if either of the parties had a beneficial interest in a property that had been a matrimonial home in this jurisdiction. If you invoke that limb of jurisdiction, then the claimant is restricted to the amount of the beneficial interest. In other words, you can't get more than the beneficial interest that's owned by the other spouse. The second safeguard to guard against forum shopping was a filter process in the form of an ex parte application before a High Court judge for leave to bring the Part 3 application. The purpose of that was obviously to filter out unmeritorious applications before the other spouse was involved in the proceedings. The third safeguard was consideration by the judge of what the commissioners described as some specific guidelines, which we will see in due course because these guidelines became incorporated in section 16, which is the main statutory provision that we're concerned with in this case. And those guidelines were to assist the court in the exercise of its discretion to determine whether it was appropriate for the English court to make an order. And these guidelines, as we shall see, focus on connection to this jurisdiction and the jurisdiction in which the foreign divorce was made, and then on financial matters arising in the jurisdictions. There was no issue in this case at any stage about jurisdiction. The wife based her application on her habitual residence here. Of some significance, we say in this case, is the fact that the wife was acquitted of forum shopping, the very feature of the reforms that the law commissioners were concerned about. Mr. Justice Mumby, who dealt with the ex parte application, and then the inter partes application brought by the husband to set aside the grant of leave, on the papers before him, acquitted the wife of forum shopping. If I could ask you please to turn to the bound volume and Appendix 1. I'd like to refer you please to page 45, which is his judgment. It's page 45, paragraph 58, towards the bottom of the page, little Roman 2. He said, "The wife cannot, I think, be accused of forum shopping, at least not in the pejorative sense of that expression. A, she did not choose to litigate in Nigeria and took appropriate steps both in Nigeria and in this country to ensure that her claims would be heard in this country. Having failed in those endeavours, I do not see that she is to be criticised for seeking what she could in Nigeria, and then, as indeed Mr. Justice Ryder had contemplated, turning to this country when the order made by Mrs. Justice Nicole Clay, who was the Nigerian judge, turned out to be so disappointing from her point of view. What, after all, was she supposed to do? Simply ignore the Nigerian proceedings and let them go by default? That would have been a very high-risk strategy indeed, not least in the light of Mr. Justice Ryder's analysis of her situation and his dismissal of her application."
Yes, that actually isn't really focusing on classic forum shopping at all. It's what he's suggesting is she's not to be criticised for shopping in two different shops. But the fact that she took great steps to try to have her claim heard in this country could very well have been forum shopping.
Can I just explain the circumstances surrounding that? In terms of the chronology of the case, the wife came here in 19...
I'm not saying that it was forum shopping, but simply that little a doesn't seem to me to be really focusing on the test of forum shopping at all. It's focusing on a separate factor, which is she actually made a claim in Nigeria.
Yes, but she made the claim...
And a claim here. So
yes. The circumstances were that the husband issued his petition in Nigeria in June of 2003, when she had been living here since 1999. Yes. So if she had been a classic forum shopper, she would have issued her application at the first opportunity, say in the year 2000, when she would have been here for 12 months. So she didn't initiate a claim here at the first opportunity. But also, she issued a petition here before she issued an answering cross-petition in Nigeria. So she endeavoured to have the matter dealt with here before she made a claim in Nigeria. But subsequently, Mr. Justice Ryder granted a stay to the husband on her petition here and refused to make an anti-suit injunction in her favour here.
And the reason why it wasn't forum shopping was that she had valid reasons, as found by the judge, for seeking relief here,
yes,
other than the fact that she was going to get a bigger share of the cake if she proceeded in this jurisdiction.
Yes. And the long-standing connection, of course.
Yes.
Yes. If I could just show you the judgment of Mr. Justice Ryder, because there is a certain irony in this. I could ask you please to look at it. It's in Appendix Part 2. Which you'll find at page 208. This is what Mr. Justice Mumby was referring to. This is the judgment that he gave on the 5th of November of 2004. And by this stage, the Nigerian divorce case had actually started. The case had been opened and it was part heard. So it's perhaps not surprising that the wife failed in her anti-suit injunction. But if I could ask you please to turn to page 4 of the judgment and paragraph 7. Mr. Justice Ryder said, were the courts in Nigeria to come to an appropriate conclusion, she would, on the facts of her own case as pleaded, here have the right to apply in the United Kingdom for permission to make an application in relation to the United Kingdom assets of the couple. So even though he was granting the anti-suit injunction, he was stating that it may well be an appropriate case for a Part 3 application.
Well, he basically granted a stay, didn't he?
Yes. Yes.
And refused an anti-suit injunction.
Yes, he did. Yes. And I'm going to come on to this later. When you look at the judgment of Lord Justice Ward, he has made the point, well, if you grant an anti-suit injunction, if you don't grant an anti-suit injunction, but you stay the English petition here on the basis that Nigeria is the appropriate forum, how can it be right to say that Nigeria shouldn't deal with the case? Well, the irony is that the judge who dealt with the application postulated the possibility of the wife making a Part 3 application in his judgment. I was dealing with the forum shopping acquittal. Could I turn next, please, to the judgment of the trial judge, Mr. Justice Coleridge, which is back in the bound volume in Appendix 1. Mr. Justice Mumby had not heard any oral evidence. He had simply considered the matter on the papers, and there had been a hearing that lasted for a full day, and he then gave a reserved judgment. Mr. Justice Coleridge, however, had a 2-day hearing, during which the parties gave oral evidence.
Can I just ask what the nature of the hearing before Mr. Justice Mumby was? Was it just under the general jurisdiction to set aside ex parte orders, or is there some special provision in the matrimonial?
There is no provision in the rules, my lord. I suppose the best way to describe it is a convention that's
There's a general principle of law that all ex parte
precisely
orders can be.
Exactly. Yes, it is that. In fact, as you will have seen from the Court of Appeal judgments, there is criticism about whether the procedure is working effectively or not. Page 65, please, in Mr. Justice Coleridge's judgment. And if I could ask you, please, to look at the top of the page, the second paragraph, Mr. Justice Coleridge said, the husband's case as to Section 16 is that the party's connection with this country has only really subsisted since separation. Mr. Scott asked why the husband should be responsible for the wife's choice to live here at very considerable extra cost. He says this would be grossly unfair on the husband, whose own case, stroke evidence, was that he himself could not afford to reside here. Mr. Scott does not shrink from accusing the wife of blatant forum shopping, trawling the globe to obtain a favourable order, and says that this is no more and no less than an appeal from the Nigerian court. He says that it is not appropriate for this court to start meddling in matters already litigated in Nigeria, that this is a black and white case in which the wife should be stopped. And if I could ask you, please, to go down to the bottom of the page, just picking up the thread of that argument. He says, the parties have a long-standing and real connection with the UK, its culture and way of life. They are British citizens. All the children are British and were born here. The wife is unquestionably resident here and has strong connections here. She would say that she has been so for a very long time. There are issues as to when the wife came here for the long term, and I have been shown a schedule based on her passports, which I accept. I also accept that the wife has spent the vast majority of her time here in the period from 1999 to 2005. She has been in this country now for nearly 10 years. Apart from that, the parties bought 2 properties here, one in 1975 and one in 2002. The children were all educated here, as a result of which they themselves have property here. It was apparent also that each of the children spent at least part of their time here and regard England as an important part of their lives. How much time the elder children spend here is far from clear, but all have homes here, and the clear impression is that there is a very strong English connection. And then, just skipping a paragraph, he said, in my judgment, the wife has established that it is appropriate for the English court to intervene, where she has been resident here since 1999, and where I am satisfied that she will continue to make her main home here, where she has her doctor and her English state benefits. I am satisfied that she is not misleading the court with a false case, and this is an appropriate case for an order, despite the Nigerian proceedings. So, my lords, we say that she was acquitted of the Law Commissioner's main concern about forum shopping. The Law Commissioners considered that the regime that they wanted to provide for would be a flexible, discretionary regime. And if I could ask you please to go back to the authorities bundle, bundle 1. At page 102. We can see how they expected the new regime to operate. Paragraph 51. Having rejected proposals for a rigid bar on applications, we are left with the alternative of a flexible discretion, under which, although an application could be presented by any person able to satisfy the jurisdictional test that we have recommended, such applications would be the subject of preliminary scrutiny by the court, which would only allow the applicant to proceed if, in the circumstances, it was thought appropriate to do so. In the general formulation of the proposed discretion, we think that it should be made clear by express statutory provision that the object of the discretion is to provide for the, quote, occasional hard case. We consider, therefore, that the court should be given power to entertain an application for a financial provision or property adjustment order, notwithstanding the existence of a valid following divorce, if in the light of all the circumstances of the case, and in the particular certain specified circumstances, the case would otherwise be one where serious injustice might arise. Our present inclination is not to favour any requirement that the applicant must establish the facts of the case to be exceptional, since he may well belong to a religious nor ethnic group in which it is not uncommon, for example, for a wife to be divorced abroad without having a right to claim financial relief. And if I could just ask you please to turn to page 109, paragraph 66, which is the concluding paragraph of the working paper, just to pick up the point about the condition precedent. The Law Commission has considered whether a Part 3 application could be made if another court in the British Isles had made an order. So in other words, if a Scottish court had made an order, could you then come to England for a Part 3 order? And they decided no. And just reading the last paragraph, they said it would nevertheless, in our view, be inappropriate to allow those divorced elsewhere in the British Isles to apply to the courts in England and Wales for financial orders. There will be few, if any, cases in which a person divorced in another part of the British Isles will have suffered the, quote, serious injustice which we believe it should be necessary to establish as a condition precedent in the exercise of the powers that we propose.
What did they mean by the British Isles?
I assume Scotland and Northern Ireland.
Well, it includes the Republic of Ireland.
That's what I was asking, yes.
I'm not sure whether they went as... I'll check that. Oh, yes, sorry, yes.
They
it says
say,
page 108.
footnote 228.
Yes.
Not.
Yes, in Scotland, Northern Ireland, the Channel Islands, or the Isle of Man. Page 60, paragraph 65. As we will see in a moment, the 1984 Act made provisions for Scotland, but not in the same provisions as applied in England. And in relation to Northern Ireland, a statutory instrument made in 1989 applied the Act in the same terms, apart from a few obvious modifications that had to be made to Northern Ireland. Can I now turn to my second main argument, namely the statutory provisions in Part 2. And can I begin with an apology, because the statute that is in the bound volume, which begins at page 112, I'm afraid is not the current and valid statute, although I do say quickly in our defence that the provisions that came later are not material to this appeal. But if it might make more sense if we perhaps work from the up-to-date statute, which I had sent over yesterday. I hope we've all been able to get a copy.
It was with a clip of materials that came over.
Yes, I do apologise.
On the cover of, I think, an email from or a note from your junior. Yeah.
No, I'm afraid I've only got the Scottish material.
When did this come?
Yesterday morning, my lord.
See, I wasn't here yesterday.
I'll arrange for...
I'm sorry about that. That's my...
No, it's all our fault. I've arranged for a copy to come up.
Please just go ahead and do it.
It's set out in the Court of Appeal judgment, isn't it?
Yes, it is. As I say, the amendments are not in any way material to the appeal. Use the stapler. Yes, if we could turn to the statute, please. And if we could start with Section 12. Section 12 permits the application for financial relief following an overseas divorce. And you will note that the breadth of the provision was quite wide because either party to the marriage may apply. There is no restriction on the application being made just by the respondent in the foreign divorce. You could actually have a situation where the petitioner in the foreign divorce was able to apply here. I think, I'll check this, but I think the position is different in Scotland. Section 13 is the filter process. It's the applicant having to apply to the High Court judge for leave to begin an application for financial relief. And in subparagraph 1, you will see it reads, no application for an order for financial relief shall be made under this part of this Act unless the leave of the court has been obtained in accordance with rules of court, and the court shall not grant leave unless it considers that there is a substantial ground for the making of an application for such an order. The subsections that follow are of some importance in this case. Subsection 2 is the one I mentioned earlier, which is statutory recognition for the fact that the court may make a Part 3 order, notwithstanding that the foreign court has made an order that provided for a payment or transfer of property to the applicant or a child of the family. That permits the dual application. And subsection 3 is also important, as I'll develop in due course. Leave under this section may be granted subject to such conditions as the court thinks fit. This appeal does not really concern the ex parte stage because, as your lordships and my lady will know, the husband appealed Mr. Justice Mumby's decision not to set aside the ex parte grant of leave, and it was referred to Lord Justice Thorpe on paper, who refused the application, and then there was an oral hearing in which my learned friend appeared before Lord Justices Wall and Wilson, who dismissed the application and gave judgments. I don't want to spend too much time on this, although I would like to just briefly refer you to the leading case of Holmes, because it is relevant to some extent to our appeal.
It was always contemplated by the Law Commission, wasn't it, that Section 13 applications should be made ex parte?
Yes, it was.
And this was so that the respondent wouldn't be troubled or put
Quite.
to expense.
Yes.
The filter was the court's
Yes.
serious appreciation of whether this was a suitable case or not. Is that provided for in the rules at all, or is this just...
No, it's in the rules. It's in the
Yes.
family proceedings rules.
Yes. Have you got the reference by any chance?
Yes, I have. It's Appendix 1. Appendix 1, at the back of Appendix 1, on page 121. It's Family Proceedings Rules 3.17.
Thank you very much.
Application is made ex parte by originating summons. There has been a number of Court of Appeal judgments, not least of all, of course, the Court of Appeal judgment in this case, concern about procedure. And if you want any assistance on that, I do have some views as a practitioner, which may or may not be helpful. If I could ask you please to look at the Authorities Bundle 1, the same bundle in which the report is found, and to look at tab 5. This is the case of Holmes, which is one of the leading cases, and in fact was the first case that the Court of Appeal considered in relation not to the substantive order, but in relation to whether leave should be set aside. And if I could ask you please to turn to page 53 of the report in the judgment of Lord Justice Purchase. He dealt with the phrase substantial ground, and what he said has really been the test, the basis that has been applied in subsequent cases. It's just below E on page 53. He said, the phrase substantial ground for the making of an application for such an order is clearly central to the issues in this application. Looking at that expression in the immediate context of the Act, I have formed the view that what is required is that the applicant should demonstrate to the court that there is in all the circumstances surrounding the application for financial relief, the orders that may or may not have been made, the presence or absence of powers to grant financial relief in the foreign forum, reasons for saying that there is a substantial ground for making an application. That is, a substantial ground upon which the court could be invited to exercise its powers under Section 12 within the jurisdiction of Section 15. In particular, when the court comes to consider such an application, it will have to take into account under Section 16(1) whether in all the circumstances of the case it will be appropriate for such an order to be made by a court in England and Wales. If it is not satisfied that it would be appropriate, and that is a positive onus, the court shall, as a matter of mandatory instruction, dismiss the application.
Surely that's going further than substantial grounds.
Sorry, Lord?
That's surely going further than substantial grounds, isn't it? It's the substantive issue that's going to be step number one to getting your relief.
What, because they had to go on and consider whether it was appropriate or not?
Well, this particular test.
Yes.
And this was an extemporary judgment on an application for leave to appeal in which the respondent wasn't called on. Was this prior to the time that there was a practice direction that such judgments shouldn't be reported or relied on as precedents?
I think it was before. Long before.
Yes. Yes.
Yes, long before, I think. I think that came in.
And it wasn't about setting aside a leave that had been given. It was an appeal against the refusal of leave.
Yes, quite.
So it's not about setting aside, which raises completely other issues.
Yes, it does. It does. That's fair to say.
But what it's doing is incorporating Section 16, the Section 16 factors into the Section 13 application.
Yes.
Which does make sense.
Yes. Which is
But
what the
as
Law
Lord
Commissioners
Phillips
intended.
says, it is also, perhaps, arguably going further than that and saying, don't only decide whether there's substantial ground for saying that the case should go ahead, but deciding whether
You're going to get something.
you're going to get something,
Yes.
which is
Yes.
taking it further.
Yes. The Law Commissioners intended that the Section 16 factors should be taken into account at the ex parte stage.
But you
Yeah,
take
but
them
it
into
makes
account
sense.
in two ways,
Yeah.
saying whether there's a good arguable case that those factors will be satisfied,
Yes.
or going further and saying the factors are satisfied.
It should probably be the good arguable
Yes.
case. Yes.
Yes.
Yes, I agree. Well, as they say, it says take into account. It doesn't say decide. So I suppose
No, if it is not satisfied that it would be appropriate, it shall dismiss the applications. That's the sentence that goes too
yes,
far. isn't it?
yes, yes, it is. It should have said if it is not satisfied that there is a substantial ground, which is actually what the statute says.
Yes.
Yes, quite. We say this paragraph is important because of the words that Lord Justice Purchase uses in the middle of the paragraph when he talks about all the circumstances surrounding the application for financial relief. He says the orders that may or may not have been made, the presence or absence of powers to grant financial relief in the forum. He's looking at what can happen, what did happen in the forum. And in a sense, looking at the outcome produced and why it was produced and how it was produced. And then if I could ask you please to look at the short judgment of sorry, if I could just ask you please to look at page 57, just staying in the judgment of Lord Justice Purchase at G. Holmes and Holmes was actually a very undeserving case for a Part 3 application because you had English spouses who had been married in England but later moved to New York. The husband issued a petition in New York and the New York court made comprehensive orders in respect of all their properties in New York and in England and for them to be sold and the proceeds divided, and also made an order for maintenance for the wife and the child. So the New York court, having made a proper distribution of the assets, it seemed surprising that the wife wanted to invoke the powers of Part 3, and what she wanted to do was to try and remain in the English property, which the American court had said should be sold and the proceeds divided. So it was always, we say, a very weak application, not surprising that the ex parte application was refused. And Lord Justice Purchase talks about the purpose of the Act. If I could ask you just look, please, above G on page 57. He said, "For my part, I do not believe that the intention of Parliament in passing this Act was in any way to vest in the English courts any power of review of, or even correction of orders made in a foreign forum by a competent court in which the whole matter has been examined in a way exactly equivalent to the examination which would have taken place if the application had been made in the first instance in the courts here." and the words I rely upon, is in a way exactly equivalent. And we say that the proceedings in Nigeria were not determined in a way that can in any way be described as exactly equivalent to the examination that took here.
But he's not propounding a general rule there, is he? I mean, that simply reflects the circumstances that obtained in that case.
Yes, he is. I agree. If we could please then turn to page 59. This is the short judgment of Lord Justice Russell, which is often quoted in these cases, and indeed was quoted in this case by Mr. Justice Mumby. Reading from the second sentence. The test in section 3.1 is, in my judgment, plainly a more stringent one. That's referring to judicial review. Prima facie, the order of the foreign court should prevail, save in exceptional circumstances, and a good case for any interference with it or adjustment of it or any supplementation of it should be apparent before any leave is granted under section 13, where the foreign court is properly seized of the dispute, as it was in this case. So far as it is possible, duplicity of proceedings should be avoided in this, as in all other fields, in the interests of the parties and their children, as well as in the interests of justice and the comity of nations. So he sees it as a strict test, a hard test, where there has been a foreign order. He's talking about exceptional circumstances, although the statute doesn't refer to that. And the Law Commissioners actually said they did not want it to cover an exceptional case. But what is significant in my submission is the use of the word supplementation, because what really happened here was that there was supplementation of the Nigerian order. And could we please look at Mr. Justice Mumby's judgment? Again, it's in the bound volume. At Appendix 1, page 47. It's paragraphs 59 and 60. This is how he dealt with the substantial ground test. At the end of the day, the real issue seems to me to be the same as it was when this case was first before me. To paraphrase what I said in my earlier judgment, is this in truth simply a case where a wife is seeking to have a second bite at the cherry following proceedings in a foreign country, which, although not satisfactory from her point of view, and although not as generous from her point of view as comparable proceedings would be in this country, were nevertheless appropriately conducted and which led to a financial order in her favour, which can be and has been implemented? Or is it, on the other hand, a case where the circumstances are sufficiently exceptional, using the word in the sense in which it was used by Lord Justice Russell, that notwithstanding the making of a significant order in her favour by the foreign court, it is nonetheless proper to enable her to pursue a second application in this country? In my judgment, this case falls into the latter category. What is, in my judgment, the very considerable discrepancy indeed between the aggregate value of what this court would consider to be the relevant matrimonial assets, some of the most valuable being located in this country, and the very modest amount of the provision made for this wife following a marriage of, I emphasize, 32 years, justifies the conclusion that there is, within the meaning of section 13.1 of the Act, substantial ground for her making the application. If I deny her relief, she will suffer hardship, in my judgment, very serious hardship indeed, being faced in all probability with the unenviable choice of either remaining homeless in this country, where she is now based and where she wants to stay, or returning to Nigeria. And the test that he applied there was approved by the Court of Appeal when the husband's application for leave to appeal was dismissed. Part 3 proceedings have attracted the pejorative tag of being a second bite of the cherry. And that description implies that a Part 3 application is a complete rerun of the same proceedings in the foreign jurisdiction. And that what happens is that all the issues are canvassed again before a different judge in a different country with a different adjudication sought. But, my Lord, we say that that is not the purpose of Part 3, and that is certainly not how it was envisaged it would be utilised by the commissioners. We say that Part 3 a Part 3 application should be case managed and directed to achieve the purpose of remitting the hardship that has been identified arising from the foreign financial order. And this is something that Mr. Justice Mumby addressed and dealt with. And he imposed, as he could do, as you remember under Section 13.3, stringent conditions as to how the case was to be run at the final hearing. And if we could read on, please, to paragraph 61 of his judgment. I think you still have the page open. He says, so in principle and despite everything else, and despite everything said by Mr. Mitchell, I accept that the wife should have leave to make her claim. In saying this, I have, of course, had regard to each and every one of the various factors referred to in Section 16.2 of the Act. But this is subject to one very important qualification. There is, as it seems to me, very considerable force indeed in Mr. Mitchell's submission that the husband should not be exposed to the kind of extensive and no doubt expensive proceedings which the wife apparently has in mind. In my judgment, this is a case where it can now be seen, even if it was less obvious when the matter was first before me, that I should attach conditions, stringent conditions, to my grant of leave. I am not prepared to contemplate a rerun of the Nigerian proceedings. I am not prepared to contemplate the reopening of factual issues which have been the subject of decision by Mrs. Justice Nicol Clay. I am not prepared to contemplate a process involving extensive further evidence, questionnaires and disclosure. Nor do I think there is any need for further valuation or other evidence in relation to the condition or value of the various Nigerian properties. The Court already has enough information on these topics to enable it to do proper justice in a fair and proportionate manner, not least bearing in mind that I propose also to impose a condition limiting the wife's property claims to the Barnet property. That's 27 Lytton Road. By this I mean a condition preventing the wife making any claim, whether a proprietary claim or a claim for property adjustment or a claim for any other form of transfer or vesting of property order, to or in relation to any real property, whether in this country or in Nigeria, save and except only for a claim for property adjustment order in relation to the Barnet property. This will not, however, prevent the wife pursuing her claims for a lump sum order and a periodical payments order. I propose, therefore, to make an order dispensing with many of the normal steps in an ancillary relief claim, and including directions designed to ensure that the wife's substantive claim can come on for a hearing as quickly and as cheaply as possible. I am quite sure that full justice can be done to both parties at a hearing lasting no more than 1 day, and at which there is little, if any, oral evidence. And he also proposed in the final paragraph, as you can see, for an appropriate order to be drawn up by counsel, and if necessary, for there to be an informal financial dispute resolution hearing before him to see whether the matter could be settled. And just in terms of that, within a fortnight of his judgment being handed down, the wife made an open offer on the 4th of January of 2007 to accept a transfer of Lytton Road on the basis of no order as to costs and a clean break. And on the 31st of January of 2007, the husband rejected that proposal, making no counter-proposal in reply, and he appealed to the Court of Appeal. So that is why the case took longer to be resolved than Mr. Justice Mumby had envisaged.
Well, the order took about 4 months to be drawn up, didn't it?
Yes, the judgment was handed down in December, and there was then a hearing to deal with costs in March. If your lordships and my lady would please turn to page 14 of Appendix 1, you will see the order and the directions that he made. In paragraph 2, he granted leave, subject to the following conditions. There was the limitation on maintenance, property adjustment order only in relation to Lytton Road, the lump sum. The findings of fact by Mrs. Justice Nicole Clay identified in an annex to stand, and then updating evidence not permitted other than to deal with current income. And then income needs to be dealt with, and then over the page, no valuation evidence in respect of any property in Nigeria, and various directions for property values to be agreed. And then, my lords, you'll see over the page, page 18, various findings of fact made by the Nigerian judge, which were to stand in the Part 3 application, subject to the discretion of the child judge in his consideration of the facts. So we say that those sort of directions and that sort of case management should result in the case not attracting the tag of being a second bite of the cherry.
Is the appellant denied the opportunity in the fresh proceedings to reopen the question of whether she'd made a contribution towards the acquisition of the Barnet property?
No. The contributions to the property were looked at in very different ways, because under the Nigerian law, as we will see, the contributions were direct financial contributions to the acquisition of the property, whereas under the English ancillary relief law, contribution is in the widest sense.
Yes, of course, but what is the significance of this sentence, in the first sentence in paragraph 2, or at least the only sentence in paragraph 2, that she had failed to prove her contributions towards their acquisition?
Well, that's what the judge found.
Yes, but how does it operate in relation to the contemplated proceedings?
I don't think, my lord, it restricted the way the wife put her case before Mr. Justice Coleridge at all.
I see.
Because her claim was based on need. She needed somewhere to live. And financial contribution in an English ancillary relief case is only one of the factors. There can be contributions in the widest sense that don't involve any money at all, because it can be contribution to the welfare of the family, bringing up the family, which obviously in this case was my client's main plank of her case.
Yes, I see.
But did the wife, in seeking to reopen it, advance a claim on the basis this is what I would have got under English law, or did she say that this is a special situation under which I have to show undue hardship, and it's the hardship I'm focusing on?
Her case was on the basis of, I'll specifically come to this in a moment, but the judge approached the case on the basis that the order he would make would only be to remit the hardship.
Yes.
And he followed an earlier decision at first instance to that effect. So although it was a general ancillary relief claim, it was targeted at meeting her needs for accommodation, namely having a transfer of Lytton Road. And this is an important matter in the case, because, again, whether or not it's a second bite of the cherry, we say that if a prior financial order has been made, not only should the judge case manage the case, but he should direct the order, when he makes the substantive order, to the hardship. In other words, he doesn't just look at the matters afresh and come up with an English order in a conventional way. And Mr. Justice Coleridge, as we'll see, deliberately said, I am not making an order in the same quantum as I would have done had I been dealing with the matter in a conventional ancillary relief case. He gave her less, and he said so. Can I now turn, please, to section 16 of the Act, which is the main section under consideration in the appeal. Section 16 incorporates the specific guidelines that the law commissions were talking about that the judge would consider in the exercise of his discretion. And under section 16.1, it reads, before making an order for financial relief, the court shall consider whether in all the circumstances of the case it would be appropriate for such an order to be made by a court in England and Wales, and if the court is not satisfied that it would be appropriate, the court shall dismiss the application. And then in subsection 2, it states the court shall in particular have regard to the following matters. And Lord, before we look at those, what the test is setting out in the test of appropriateness is a general consideration of all the circumstances of the case, and then the specific matters in subsection 2, A, B, and C, which deal with connection to England and Wales. B is connection to, in this case, Nigeria. C is connection to any other country, which isn't relevant in this case. And then D, E, F, and G all deal really with the financial matters arising in each jurisdiction. D doesn't arise here because that concerns an agreement arising in a foreign jurisdiction. That would, for example, be if the parties had had a post or prenuptial agreement.
Or if they'd been party to a community property regime.
Yes. Or a deferred dower, I think, is another example the law commissioners gave. E is obviously highly relevant here. It's where the foreign court has made an order for the wife or any child of the family, and the extent to which the order has been complied with or is likely to be complied with. F does not arise here. It deals with any right which the applicant has or had had to make an application for financial relief in the foreign forum. And then G and H are relevant here. It deals with the availability in England and Wales of any property in respect of which an order under this part of the Act can be made in favour of the applicant. And then H deals with the extent to which any order made under this Act is likely to be enforceable. So G and H are relevant. I is not relevant. It deals with the length of time which has elapsed since the date of the divorce. You will see that the heading for section 16 states duty of the court to consider whether England and Wales is appropriate venue for application. That side heading, using the words appropriate venue, gives an indication of forum convenience considerations. But if you do a word search on the 116 pages of the report and the working paper, the word venue only comes up in the heading here. And if you also do a word search for forum convenience, it simply doesn't come up at all. And that is because there was no discussion in the working paper or in the report about venue or forum convenience matters, which is perhaps surprising, bearing in mind Dr. Peter North was one of the commissioners.
May not be surprising, may simply indicate that it was present to the mind of the commissioners and they thought it wasn't relevant.
Yes. Well, it's certainly not one that came up in the working paper, even though the issues they looked at were quite wide-ranging. If we want to know how the commissioners viewed this section, we turn to the authorities bundle at page 6 in tab 1 in the report. And we can see that they considered in the second sentence that the test of appropriateness is necessarily an imprecise one. It's page 6, my lady.
Thank you.
Paragraph 2.6. So they didn't define the scope and ambit of the test at all. They simply said the suggestions which we made in the working paper about the circumstances to which the court's attention should be specifically directed in the legislation were widely supported on consultation and are substantially embodied in the draft bill annexed to this report. We believe that they will provide an adequate framework for the exercise of what must inevitably be a somewhat difficult jurisdiction. So we really don't get a great deal of guidance from them, but obviously they didn't, as the Court of Appeal did, consider that this section really dealt with the forum conveniens test.
I mean, it is dealing with, as I understand it, it is dealing with whether or not, because you consider this before you make the order, it's dealing with whether or not you are the appropriate court to be making an order at all. Because it's only when you get into 17 and 18 that they then tells you what you're actually going to do.
Yes.
I mean, to that extent, it's sure. I mean, the Law Commission presumably perused the headings of the sections as well. So, I mean, there they are. They didn't think appropriate venue was an inappropriate way of looking at the matter.
We say, my Lord, that although foreign convenience issues are obviously engaged in these cases, because they inevitably will be, because you're dealing with two jurisdictions, that they were not proposing in Section 16 a strict foreign convenience test. Because really because of the language. I mean, the language is not proposing a test for the court to decide with which jurisdiction the marriage has the closest connection. It's not proposing a foreign convenience test where the court should undertake an inquiry to find the natural and appropriate forum. All those words we're used to seeing when such a test is... But
Section 16(1) does say that the question is whether it's appropriate for the order to be made by a court in England and Wales. So that's foreign convenience.
Yes, I'm not saying that foreign convenience is not engaged. It plainly is, but it should not be determinative, which is the way the Court of Appeal approached the case. They said once you've found your main forum, your forum of the marriage, then if they've made an order, then that's an end of the matter.
Well, you've just got to do what's in Section 16.
Section 16 is really a test to prevent forum shopping. This is one of the specific guidelines that they had suggested, along with the jurisdictional requirements and with the filter process. These factors were to prevent forum shopping primarily.
But what makes the forum conveniens may be different from the factors that would make forum conveniens applying the Spiliada test.
Yes. Yes. Yes, quite. The reason why we say that a foreign convenience test, a strict foreign convenience test, should not be incorporated here is that the very foundation of the Act was that the law commissions had decided that there was not one right system of law that should necessarily be applied to the exclusion of all others in certain cases. In cases where there were links with other jurisdictions, you don't look to decide which is the right law and the only law. You can look to see whether other jurisdictions can also be an appropriate jurisdiction to make a further order to supplement the order made by the foreign court who made the first order.
It's not an either-or type of exercise,
No.
which foreign convenience is.
Quite. And the reason underlining this, as I've mentioned in our written case, is that in a convention forum convenience dispute, you have concurrent proceedings in two different countries, proceedings going on at the same time, and one court has to decide which country will determine the dispute. In a Part 3 application, you do not have concurrent proceedings because one court will have already decided on the divorce, it would have made the order, the couple are divorced, and it will have gone on to made a financial order. So you're not looking at competing jurisdictions. It's a very, very different argument. And
the holistic solution to the problem may be contributed to by various fora in Nigeria and in England.
Yes. The whole cornerstone of Part 3 is a recognition that in some cases there is just not one right system of law that can do proper justice to both parties.
Well, it wouldn't have been legislated at all if that hadn't been the case, would it? Because otherwise, it would be decided where the divorce was,
Yes,
and that would be that.
yes. Quite.
The whole purpose was to say, even though the appropriate court to grant a divorce has granted a divorce, there may be circumstances, query what those are, in which it's appropriate for a court here to deal with some aspects of the consequences.
Yes, yes, quite so. Can we just look, please, at the statutory language that's used? Because you will see that in subsection 2A, it deals with connection, not of the marriage with England and Wales, but the connection which the parties to the marriage have with England and Wales. So my client does not have to show just her connection to this jurisdiction, it's both parties. Similarly, the same applies to Nigeria. It's the connection which both of them have to that jurisdiction. Also, connection should not be confused with residence. Residence is a different concept. What the legislation is dealing with is connection or attachment to another jurisdiction. And the husband himself is a very good example of somebody who does not reside here, but he's somebody who has had a long-standing and enduring connection with England that began in the mid-1960s. If the law commissioners had intended to have provided a foreign convenience test, then we say they would have incorporated the language in the Domicile and Matrimonial Proceedings Act of 1973, because that was a statute that they were looking at because it dealt with the jurisdictional requirements for a divorce. And if I could just ask you please to look in the authorities bundle at tab 3. This is the well-known case of Dompierre, a case decided by the House of Lords in 1987. It concerned a French couple who had lived in London during the marriage, but towards the end of the marriage, the wife had left and went to live in New York, taking their son with her. She told the husband she was not returning to England, and she left and went to New York, and the husband issued proceedings in Paris. And the wife then followed with proceedings in London. Her connections with England were described by Lord Templeman as tenuous. And the husband applied to stay her petition in England, and the House of Lords allowed his appeal and stayed the petition, and said that the test at common law in cases of forum non-conveniens should also be the test under the statute dealing with concurrent divorce proceedings. And if I could ask you please to turn to the speech of Lord Templeman at page 98 of the report. I just wanted to refer you to the specific section that they were looking at in relation to whether or not there should be an imposition of a stay when there were concurrent divorce proceedings. And looking at the second paragraph, he said, where there are concurrent proceedings in England and in another jurisdiction in respect of the same marriage, under Section 5, subsection 6 of the Domicile and Matrimonial Proceedings Act 1973 applies, and paragraph 9 of Schedule 1 to that Act provides that the English proceedings may be stayed if it appears to the court that the balance of fairness, including convenience, as between the parties to the marriage, is such that it is appropriate for the proceedings in another jurisdiction to be disposed of before further steps are taken in the proceedings in England. In considering the balance of fairness and convenience, the court shall have regard to all the factors appearing to be relevant, including the convenience of witnesses and any delay or expense which may result from the proceedings being stayed or not being stayed. So here we have a specific forum convenience test in a statute dealing with concurrent divorce proceedings that the law commissioners, as they say in their report, were looking at because they were dealing with the jurisdictional requirements for divorce, which are also in this statute.
Does it matter whether you put the label forum convenience on the factors in section 16?
Yes, my Lord, I think it does, because it was not in their contemplation that it would ever be a forum convenience argument. It's not discussed at all.
Yes, but that's just a label. The court still has to go through these hoops. It may be that Mr. Justice Munby did it at too early a stage.
Yes.
But at some stage, the court has to go through these hoops before making the order.
Yes, I agree. I agree. But
What's the Latin for appropriate?
I don't know.
Convenience.
Convenience, yes, or convenience.
I'm not sure that it is.
It is. That's the whole point.
I thought convenience was convenient, but
No,
that's
there's
exactly
case law telling you that
That's why I asked.
Convenient forum.
So,
in the Court of Appeal,
of course, it's appropriate in the particular context, isn't it?
yes,
Or convenient in the particular context.
but we say the test here is not whether or not Nigeria is or is not the appropriate forum. The test is whether it is appropriate for the English forum to make a further order. And in order for the court to be satisfied that it is appropriate, it has to look at the connection with this country. Because it's the connection with this country that decides whether or not the applicant is a forum shopper or not. If you can show, as I mentioned when I referred you to the definition, if you can show that you have a connection with this country, then you are likely to be acquitted of forum shopping, because you're making a claim in a forum that is a forum in which you have a jurisdiction. As I mentioned, it's one of the unfortunate features of this case for the wife that she didn't issue her petition at an earlier stage in this case, because she had jurisdiction to issue a petition here, probably from the summer of 2000. So, my Lord, we say that when the Court of Appeal said through Lord Justice Ward that when you look at section 16, what the court has to do is to identify which court has the closest and most appropriate connection in order to find one forum. That is the wrong test. The statutory language is neither consistent with that, nor is it justified. So, sorry, it's neither justified by the language of the statute or consistent with what the Law Commissioners intended. It's also interesting, if we might just digress for a moment, to look at the position in Scotland. And you'll find further on in the clip where you're looking at part 3, if you go to part 4 of the Act, which begins at section 28, you can see the test that's applied in Scotland. Section 28 deals with circumstances in which a Scottish court may entertain an application for financial provision. And it says, where parties to a marriage have been divorced in an overseas country, then subject to subsection 4 below, if the jurisdictional requirements and the conditions set out in subsections 2 and 3 below respectively are satisfied, the court may entertain by one of the parties for an order for financial provision. And then the jurisdictional requirements are more onerous in Scotland because the applicant has to show not only domicile or habitual residence, but also, as you can see under B, that the other party was domiciled or habitually resident at the appropriate time or owned a property in Scotland. And then when you look at the conditions in subsection 3, it talks about the divorce falls to be recognised in Scotland. The other party to the marriage initiated the proceedings for divorce. The application was made within 5 years. A court in Scotland would have application to entertain an action for divorce. And then, significantly at E, the marriage had a substantial connection with Scotland. So it's looking at the link to the country where you're making your application. It's not... So certainly these conditions could not be construed as a strict forum conveniens test.
Was there a report of the Scottish Law Commission?
Yes, there was. There was. I'm afraid I haven't read it, but if you look in the Law Commissioner's report, you will see reference to it. It's page 3 of the report. At the top, they talk about publishing the working paper, disseminating it, and they say we also discussed the working paper with the Scottish Law Commission, who issued their own consulting paper. We understand the Scottish Law Commission expects to publish a report containing recommendations in the future. So, my Lord, in relation to the connection sections, subsections in section 16, we say that the purpose there is to look at the ties and links with this jurisdiction and the foreign jurisdiction, not just by the applicant but by both parties. And what the court is really asking itself is this: is the party's link with this jurisdiction so tenuous and transitory that the applicant is a forum shopper whose application should not be entertained? And that would be consistent with the Scottish statute as well. In terms of connection, I would like to deal, unless you consider that you've read enough of the papers to know enough about the facts of the case, just to deal with what exactly the connection has been with this family and this jurisdiction. Because as I mentioned when I opened the case, that it's difficult to see that there is one aspect of their lives that hasn't been connected to this jurisdiction. They lived here before they met for a few years. They met in 1965. The husband was called to the bar in 1965. They then married here in London in 1967. They started married life living in London, and the husband worked here for 8 years, from 1965 to 1973, before he returned to practice law in Lagos. And during that period when they lived here, the elder three children of the marriage were born here. And in 1972 they became British citizens. The wife joined him back in Nigeria in 1974, and in 1975 Lytton Road was purchased. The husband lived in Lytton Road for 2 years, between 1976 and 1978, when he was doing further studies here, and the wife joined him. and then the wife returned to England when their fourth child was born in 1980. It is significant that all the children, bar the youngest, were educated here. And Lytton Road was used as a family base in London. And it has always been there for their exclusive occupation. It was never let out. It was available for the family. And as the husband said in his affidavit to the court, he used to come over once or twice a month to see the children and in connection with his practice. And on his case, the wife came over at least twice a year for not more than 2 weeks at a time so that she could see the children. And it's quite clear that he accepted that they both paid regular visits to London. And even after the marriage had ended in 1999, when the wife came to live in Lytton Road, the husband bought another property in London at 26 Windmill Drive. From the disclosure in the case, it's clear that he, not surprisingly perhaps, has a bank account in London with NatWest. And he regards London as the centre for his medical treatment because he has been a patient at Moorfields Eye Hospital for a number of years. And indeed, he was seeing an eye consultant in Harley Street only last year. And as I mentioned, the children, 4 of them have a property in this country. So, my lord, the long-standing and enduring connection of this family to this country is very significant. And in particular, in relation to Lytton Road, there has been a rather sterile debate of whether it was a matrimonial home or not. Well, if a matrimonial home is defined as being their main matrimonial home for most of the marriage, then it probably wouldn't be, because that would have been in Nigeria. But if a matrimonial home is defined as a property purchased during the marriage, which the husband, the wife and the children used to live in from time to time and available for their exclusive occupation, then it is a matrimonial home. It's also the property that the husband has owned the longest, and definitions, we say, are completely irrelevant, as Part 3 is not confined to a matrimonial home because it can be directed at any property wherever situated. Can I next turn, please, to the financial matters in section 16.2, which deal with the financial relief given by the order of the Nigerian court and the availability of property here. The starting point in any divorce financial dispute is to list and prepare a schedule of assets and to value them. And the schedule of assets is probably the most important document in an English and civil relief case. It's rather like a balance sheet for a company. And if you turn to Appendix 1, page 75, you will find the schedule of assets that Mr. Justice Coleridge used in this case. Just looking at the list, page 75. 27 Lytton Road is an unencumbered property. 26 Windmill Drive was the property that the husband purchased in 2002. Plot 2 on Tincan Island is the house on Tincan Island that had been the main family home when the parties were living in Nigeria. That's the property that the wife had the life interest in. And the next property, plot 17 in Lekki, that is the husband's house. It's where he resides, and it was in the process of being built when the parties separated in 1999. The other assets, as you can see, in terms of value, are irrelevant. If you add up the net equity in the 2 English properties, it comes to £528,000 £125, which is 75% of the total assets in the case. There appears to have been no equivalent schedule of assets used in the Nigerian proceedings, and perhaps surprisingly, there were no valuations obtained of the two English proceedings either in the Nigerian proceedings.
But if there's no power to transfer, and it rather looks as if the judge was looking at it in terms of old-fashioned property law,
Yes, quite.
as to the wife's interest, well then there wouldn't be, would there?
I suppose it's irrelevant.
Yeah.
I suppose it's irrelevant in that context, yes.
You're not drawing up a balance sheet in the same way, if that is the approach in Nigeria, which, of course...
Well, the Nigerian approach, when we come to look at the judgment, it would seem, is not based on the way we would approach the case by drawing up a schedule of assets, looking at values, and the judge deciding what was a fair outcome in the circumstances of the case.
Well, I wasn't around before 1971, Mr. Dyer, and I suspect you weren't either.
I certainly wasn't.
No. But I'm not sure that such a schedule would have been drawn up then, because it would have been regarded as irrelevant.
Yes, I think that's right, because they weren't looking at proportions being allocated to either party.
Wasn't putting everything into the pot
No.
and then saying, how do we share it
No,
out?
quite.
It was how much provision should X make for Y
Yes,
on a needs basis.
on a needs basis. Yes, quite so. Quite so. If you could please turn back in the bound volume to our written case. On page 18. At paragraph 70, we have provided a table showing the outcome produced by the Nigerian order. And this is the striking discrepancy or disparity between the position of the parties. As you can see under the husband, he keeps Lytton Road and Windmill Drive. I've left, perhaps unfairly on reflection, Tincan Island in his schedule, but he would, I suppose, qua trustee, still own the property if the wife had a life interest. And then his own property, after deduction of the mortgage and costs and the payment of the lump sum to the wife. And then in relation to the wife, she received a lump sum of the equivalent of £21,000. She had to pay her costs, and then she had her life interest, which I haven't valued. But even if you just take out the value of Tincan Island in the husband schedule, you can see that there is a striking disparity in the allocation of assets between them.
It's not right, is it, to deduct the costs when looking at this?
Well, I've deducted costs on both sides.
Quite common.
That's through English eyes. That's what we do, and I've done it fairly because I've done it for both. So that's the net position, if you like. That's what the outcome was in Nigeria, subject to perhaps deducting Tincan Island from the husband schedule.
And attributing some value to it. Yeah.
Yes, but
For her.
it's very difficult to do that, to value the life interest. So, my Lord, looking at the disparity here, we say that Mr. Justice Coleridge was right to adopt Mr. Justice Mumby's long judgment and to proceed on the basis, in making the substantive order, that the Nigerian ward was inadequate and that the substantial disparity between the parties justified a further order being made by the English court, because he could see, and indeed so he found, that the wife was going to suffer severe financial hardship if she was going to remain living in this country with the award provided for by the Nigerian court. Mr. Justice Coleridge receives quite a lot of criticism from Lord Justice Ward about the fact that he relied upon Mr. Justice Mumby's judgment, which was a long judgment running to 64 paragraphs. And Lord Justice Longmore in the Court of Appeal also said, well, the parties were hardly going to thank Mr. Justice Coleridge if he was going to descend into the amount of detail, again, that Mr. Justice Mumby had embarked on, and indeed the Court of Appeal had embarked on. He was entitled, we say, to have adopted what was said below, and to move on to the next stage, which was whether to make a further order.
So it wasn't really below at all. I mean, it was a parallel decision which had decided the first issue.
Well, it had gone into a great deal of detail, perhaps more detail than was necessary.
Yes.
But nevertheless, obviously, because the husband put forward the arguments he did, Mr. Justice Mumby had to go into quite a lot of detail. And it really isn't right. We say that my client should be in the position of being the victim of criticism of a trial judge for following an order that had been made and a judgment that had been given by a High Court judge, which was then approved by the Court of Appeal.
Well, Justice Coleridge did ask himself the right questions.
He did. Yes, he did. He did, as the Court of Appeal accepted. It was one of those cases where he obviously took the view that the litigation, as he said, had been going on for a very long time, and he wanted to give a judgment. I think it was on a Friday, he was going on circuit the following week, and he wanted to wrap the matter up. He didn't want the parties being subjected to further litigation, especially as my client is obviously in receipt of public funding, and it was right that he gave his judgment there and then. And if the judgment isn't as detailed as perhaps it should have been, the one really simple point to make is that really nothing much had changed on the papers between when the case was before Mr. Justice Mumby and when Mr. Justice Coleridge dealt with the case. There was a substantial body of affidavits. All the issues that were raised by my learned friend before Mr. Justice Coleridge had all been canvassed before Mr. Justice Mumby. So there was nothing new in the case. Nothing in the evidence radically altered anything in the case at all. In fact, if anything, from the husband's perspective, the case became stronger for the wife because Mr. Justice Coleridge accepted as a fact that she had lived here really for most of the time since 1999.
Mr. Justice Mumby should have been asking himself the question whether there were substantial grounds, but in fact he went much further than that. Mr. Justice Coleridge should have been asking himself the question whether it was appropriate in the light of the Section 16.2 factors to make an order. He did that, and in so doing, he incorporated the enormous amount of detail that Mr. Justice Mumby had gone into in dealing with those factors.
Yes, quite so. Because Mr.
So between them, they have covered all the ground.
Joint judgment. Yes.
I had another look at Lord Justice Purchase in Holmes and Holmes, and I did him an injustice, in fact, because what he was saying was when you're considering whether substantial grounds, you've got to ask yourself substantial grounds for satisfying the Section 16 test.
Yes.
So you've got to actually look at it, and if you decide the case is bound to fail on the Section 16 test, then you chuck it out straight away.
Yes, quite.
But he wasn't going so far as to say you had to actually decide that it was going to succeed before you.
No. You had to see whether, because you were operating a filter process, you had to have an eye on what would be happening at the final hearing when it was the test of appropriateness. Yes, quite. So, my Lord, we say, bearing in mind the judgments that had preceded him, he was entitled to find that the Nigerian award was inadequate, and he was entitled to find that the wife had will suffer serious hardship. And he was also entitled to find, as he said, that the parties have a long-standing and real connection with the UK, its culture and way of life.
Supposing that you had a case where the wife, should we assume, in this country was independently wealthy,
Yes.
But if you looked at all these criteria, she fulfilled all the criteria in section 16. She had all the connections and all that stuff.
Yes.
And there hadn't been she hadn't got a very good divide
Yes.
on what was there. Would she be a person? No.
No.
You say no.
No.
Why is that?
Well, my lord, because if a foreign court has made an order, then the purpose of Part 3 is to remit the hardship, and you've got to identify the hardship.
But where's that? Where do you find that particular criterion?
My lord, what I base that on is a decision of Mr. Justice Bodie, which was referred to by Mr. Justice Coleridge and used by him in approaching the cases he did. Can we please look at that? It's in authorities.
Section 16.2 isn't an exhaustive list in any event.
No, it's all the circumstances as well.
What you've actually got to say, Mr. Dyer, is that packed into appropriate is what the Law Commission had in mind in its report, which is serious injustice,
Yes.
hardship, and so on.
Yes.
There's no other place
No.
in Part 3 that
No.
contains these.
No. The difficulty,
these phrases.
No, quite. The difficulty I have is that the Law Commissioners said that they wanted to provide for the occasional hard case. And they said that the condition precedent was serious injustice.
It might be very unjust what had happened. If she happens to be independently wealthy, what happened to her divorce might be unjust, but she wouldn't be in hardship.
No, my lord,
You need to have the hardship.
Yes, I mean, I was going to give you an example of, let's say, for example, that the assets in a case were £10 million, and the wife obtained an award for £2.5 million. Well, even though, for various reasons, she may be able to get through various hoops, she may not be able to show any hardship, because £2.5 million may be a reasonable amount for her to live on in her circumstances. Can I take you to the case, please? Which you will find in authorities at tab 2. It's a first instance decision of Mr. Justice Bodie. It's a very unusual case, rather hilarious in some respects. It concerns a very short marriage between a Texan husband and a lady who was of Polish origin. And the connection here is that the husband had bought a home in England. But they got divorced in Texas, and the Texan court really made no provision for the wife at all, and no provision in relation to the English property which the husband had kept in his sole name. If I could ask you please to turn to paragraph 98. At page 459. Mr. Justice Bodie said, "It seems to me that the English court can be heard to say that although an applicant has just got over the section 16.1 hurdle, nevertheless it is only appropriate for the English court to intervene with financial relief to the minimum extent necessary so as to remedy the injustice perceived to exist without intervention. In my view, this is just such a case." Now, that was not based on any other authority. That's Mr. Justice Bodie on his own, but it was cited to Mr. Justice Coleridge. And if we go back, please, to the bound volume to Mr. Justice Coleridge's judgment. at page 68. Sorry, there's an earlier reference.
64,
Thank you very much. Yes, it's the bottom of page 64. He said, in addition, both parties referred me to the decision of Mr. Justice Bodie in AVS, in which he set out a short test and observed that if the threshold is crossed, the provision made after a foreign order should be the minimum required to overcome the injustice, i.e. not a complete rerun, as if these were domestic or ancillary relief proceedings. I agree with him.
How is that to be reconciled with section 18?
It's not. Simple point, it's not. It's not at all. There is no distinction in section 18 between how you approach the case, whether or not there's been no financial order abroad or whether there has been a financial order abroad. And there's no distinction as to how you assess the foreign order in terms of the order that you make in England. Once you're through the gate, you can have all the powers that you can make under the domestic legislation in the Matrimonial Causes Act, and you work on the same principles as you would decide a conventional application. The only exception is if you bring a claim based on there being a beneficial interest in a property here. In other words, if you don't rely on habitual residence or domicile. The restrictive approach to the provision of further financial relief really comes from from what the Law Commission has said about providing for an occasional hard case and remitting hardship. Actually seeing that there is a need that needs to be addressed that hasn't been dealt with by the foreign jurisdiction. That's what informs all these authorities. But it's not consistent with the statutory language. And it's perhaps surprising that the language isn't stricter.
We can hardly just apply the inner thoughts of the Law Commission rather than the words which Parliament enacted. Can we?
No,
they all. I mean, I know nowadays people read all these things, but I mean, we do have to actually to read the statute
Yes.
to see what it says.
Yes, quite.
Is the effect of section 18 that one starts with presumptions about 50% split and all of the rest of it in these cases?
If you're applying the English law in relation to the division of assets following a divorce to a Part 3 case, then yes, you would. You would apply cases such as White and White and Lambert and Sharman.
But is it your submission that that's what the court has to do?
In my case, no. No, certainly not.
So what is your submission as to legal principle?
My submission is that in the way the Act was supposed to operate according to the Law Commissioners, namely to remit hardship, in a case where there has been a prior financial order, the order of the English court should address the hardship that can be identified. In this particular case, it would be my client's need for housing.
Yes, it would be surprising if Parliament intended that in these cases, once you got through the gateway and the court was considering whether it was appropriate to make an order, and once it decided it was appropriate to make an order, simply to apply the whole of the English domestic law as to financial provision.
Yes, quite.
Well, on the other hand, if you look at section 29(2), which deals with disposals of application in Scotland,
Yes, it's the same.
well, it so as to place the parties in the financial position they would have been if the application had been disposed of in an action of divorce in Scotland.
Yes.
And that sounds as though you just treated it as though it were.
I agree. But, my lord, there must...
You don't have to go that far in order to succeed
No,
in this
you don't.
appeal, is what you're saying.
But you do have to state the principle.
Principle. We've got to understand the principle.
No. I mean, if the case was dealt with, if this case had been dealt with in London, bearing in mind the length of the marriage and the indirect contributions my client has made, the inevitable outcome, we would say, would be an equal division of the assets. The court would have provided for each party to have had £350,000, either in properties or in cash. That would have been the net effect of the outcome here. But
There must be some constraint implicit in the fact that among the background to the case is the circumstance that there were proceedings in Nigeria.
Yes, that's one of the circumstances of the case.
But that hasn't received explicit expression in the legislation.
No. No.
Well, in Scotland, it would appear that you take that into account and deduct it, but you
Yes.
produce the overall effect.
Yes,
Yeah.
quite.
I mean,
Be quite interesting to see the Scottish report.
Yes, I'll see if we can get that. I suppose perhaps one of the reasons why the law commissioners didn't address this in the way we are is that they were then dealing with ancillary relief cases that were not as generous as they are now.
I had been going to suggest that that might be the case.
Yes.
And of course, somebody will correct me if I'm wrong, but I believe that the current law on financial provision in Scotland came after this.
to be honest,
I think it's 86.
Yes,
Yes, it is 86.
Yes, it is
Yes.
86.
Yes.
It is 86.
And that obviously broadened the powers of the Scottish courts
Yes.
fairly considerably, although being more prescriptive in the principles which they had to apply. At the time when this Act was passed, one wasn't contemplating white and white type
No.
settlements.
No, quite so. In fact, at the time at the time this Act was passed, it was courts meeting needs, reasonable needs, and nothing more.
On the other hand, I mean, I don't know whether the Scottish Law Commission were responsible for these sections which we have here, but if they were, then they must have included Eric Clive, who must have had all this stuff in his head, because if it came out in 86, was enacted in 86, it must have been virtually finished by the time this was being considered.
Yes.
So it would be very surprising if they had introduced a test for Scotland, which they thought was going to be immediately rendered inappropriate in some way
Yes.
by legislation which they must have known was coming. And it has never been. I mean, there it sits, and so if it is operated today, presumably it's operated under the system which is in operation in Scotland.
We have searched for some Scottish cases, and the only Scottish case we could find, that's both sides have searched. We found one Scottish case that dealt with recognition of a foreign divorce and the opportunity for the wife to make a claim under the Scottish legislation. And then we found the substantive order that was made in the case, and it was just treated as a conventional ancillary relief case, although the amount that the wife received was a very, very small amount, something like £16,000. It's not a case that merits further consideration. So, my lords, I do agree that the legislation really enables the court to make any order it likes on the basis of the law prevailing at the moment. Although, as I would say, we say that would be an inappropriate way to apply the Act if there's been a prior financial order, because it would open the applicant up to the charge of having a second bite of the cherry, and the English court acting as a court of appeal of the foreign court. If you restrict the ambit of the provision that's made, then that, we say, does not justify those pejorative tags being attached to the application. Can I next move on, please, to just one case I'd just like to refer your Lordship and my Lady to in relation to how the Act is applied in the Republic of Ireland. It's a case called MR.
Just before you do, is it right to read the Commission's report as saying that once you've got over the hurdle of establishing your jurisdiction, you are only entitled to such relief as will obviate hardship?
Not on a strict reading of the...
No, they don't say that.
No,
they say, point number one, you can't reopen the matrimonial jurisdiction unless you've really suffered hardship. But once you do reopen it, then you've established your jurisdiction and you're entitled to the relief that the jurisdiction normally provides to anyone who's brought proceedings there.
Yes, that's correct. But Lord, as we said, I think that has to be viewed in the context of the sort of awards that were being made in 1980, which were different to the awards that are being made now. I mean, certainly if you think of maintenance, I mean, we've obviously only been talking about capital provision, but if you dealt with a case that only concerned maintenance, and the wife and the children needed maintenance, and no maintenance had been awarded in the foreign jurisdiction, then why shouldn't she get the level of maintenance that's appropriate in this jurisdiction? Because if she's living here, then her needs are going to be assessed on an English standard. So perhaps if we think of just maintenance alone, the law as it's applied here may be appropriate. If we're looking at capital provision, when capital provision's already been made to some extent by the foreign order, it may not be so appropriate. In the clip we sent over yesterday, we enclosed a report. It should be the second document in your clip. It's a case called MR and PR. It was included in the authorities bundle, but I'm afraid it was badly bound, and parts of it got chopped off, so I thought it was better if we had a better copy. It's MR and PR. It's a decision of the High Court in the Republic of Ireland, a decision of Mr. Justice Quirk in July of 2005. I don't know if anybody needs a copy.
If you had one, it
Yes,
would be-
certainly.
Yeah.
Apologise, thank you.
The Family Law Act 1995 in the Republic of Ireland has very, very similar provisions to Part 3. And if you look at the first page of the report, you will see that Section 23A provides that an application shall not be made for relief unless the court has, on an ex parte application, granted leave for the making of the application. The court shall not grant leave unless it considers there is a substantial ground for so doing. And then Section 26 of the Act sets out criteria upon which the court shall have regard in considering the appropriateness of making a relief order, including the connection which the spouses have, and so on. So it's a similar statute. And if you go on to page 521, Mr. Justice Quirk deals with the similarity between the Irish statute and the English statute. It says, to date there have apparently been no cases reported within this jurisdiction where consideration of Section 23 of the Act of 1995 has been required, where in England the Matrimonial and Family Proceedings Act 1984 contains provisions similar to the provisions of Section 23 and 26 of the Act. And it says Section 13 of the 1984 Act is similar but not quite identical to Section 23, and Section 16 of the 1984 Act is similar but not identical to Section 26. And then he goes on to say that some of the reported cases in England have been referred to in the course of the case. The facts of the case are not particularly relevant. They concerned an Irish couple who had gone to live in Spain and the husband had issued proceedings in Spain, and he had come to a deal with the wife where he paid her £50,000 in full and final satisfaction of her claim, and there were no Spanish financial proceedings and no Spanish order was actually made. They only had the agreement. And it would seem that the outcome provided by that arrangement was inadequate, and it looks as though the the husband hadn't been full and frank about his financial circumstances. And if we could just pick up at page 532, Mr. Justice Quirk just deals with the outcome achieved in Spain. He says, on the evidence, the outcome achieved by the court in Spain in October 1996 was unfair and unjust to the applicant in the circumstances. Having regard to his means and financial circumstances at that time, the sum of £50,000, from which the applicant received £46,000, was inadequate to discharge the respondent's financial and other obligations to the applicant arising out of their marriage. And then if you look over the page, please, at 533, you will see what he considered the statutory relief was aimed to provide. It's the 4 paragraphs up from the bottom. He said the statutory relief granted is not intended to compensate the applicant for past financial or other hardship or inequity. It is intended to alleviate present inequitable financial or other hardship or reduce circumstances caused by a seemingly unjust outcome resulting from divorce proceedings in another jurisdiction where no comparable remedy is now available to the applicant. It is intended to do so in a just and equitable fashion. And we say that that is similar to the way Mr. Justice Bodie approached the case in S&S by restricting the amount of the award to the minimum necessary to remedy the financial hardship. Dealing with my next section about how Part 3 should be applied, we've already dealt with the problem about the statutory language once the gate is opened and the way the law commissioners dealt with the case. And I'd like to make these submissions: that the discretionary powers of the court under Part 3 should be operated, we say, in a flexible way, focused on remitting the hardship and providing a bespoke solution. And that is because the circumstances that will arise in these cases, which involve other jurisdictions, will be so varied in each and every case. It's often said in domestic cases that no 2 cases are the same and cases are fact-specific and decided on specific facts, and of course that's correct. But in a Part 3 case where there has been a prior financial order, the range of circumstances that the court has to look at under Section 16 are very considerable and will vary so much from case to case because you're obviously dealing with different nationalities and different countries. So that's why we say it should be flexible and focused on providing a bespoke solution. And if it's applied within that sort of framework, where it's aiming to remit the hardship that can be identified, then these pejorative tags about being a second bite of the cherry really are not apt. And if the English court makes an order supplementing the foreign order in those sort of circumstances, then it would be wrong to characterise that as being an appeal from the order of the foreign court. Because a learned friend's going to say, we've just had a second bite of the cherry, it all went in, it all was canvassed in Nigeria, and that what Mr. Justice Coleridge was doing was really acting as a court of appeal on the order made in Nigeria. But we say no, because the whole purpose is a flexible solution aimed at dealing with the injustice that can be seen. And we also submit that when the court considers whether or not it's appropriate to make an order as part of all the circumstances of the case, it has to consider the impact on the state purse. Because as a result of the foreign order, a Part 3 applicant may be reduced to being reliant upon state benefits or having to apply for local authority accommodation. And that is a very relevant factor in most Part 3 cases, because the applicant, in 9 cases out of 10, is going to be here in order to satisfy the jurisdictional requirements. And his or her target may very well be a property in this country that he or she wants to live in. And we say it is contrary to public policy to cast upon the public purse an obligation that should really be borne within the family. If the means can be found to provide for the wife, then why should the public purse have to pay? And that, we say, is a relevant argument when we come to consider comity.
In which part of the consideration do you insert this business about the public welfare, or whatever it is?
In all the circumstances, my lord.
In all the circumstances, in section 16?
In 16. Section 16.
Well, it's 18, isn't it, really?
Yes, that's right. I'm just getting lost.
Yes.
What we're talking about is this the section 16 before you decide whether you're going to have jurisdiction, so to speak, to make the order, appropriate to make the order, or are we talking about when you're making the order?
Section 16. So Section 16, because Section 16 says you have to consider whether in all the circumstances of the case it would be appropriate.
Yeah.
And then you're directed to look at specific circumstances.
Yes, but with respect, you're talking about what sort of order should be made.
Yeah.
You're talking about what the purpose of the order should be, which is a Section 18 question rather than a Section 16 question.
Yeah.
You've got over the hurdle of, is it appropriate to make some sort of order? And you're saying, well, what sort of order should we be making?
And Section 18 uses very similar language, all the circumstances of the case,
Yes.
and have regard to the matters that Section 25 of the 1973
Yes, it
Act
does.
uses.
Exactly. And then
Yes.
you look at them, and that's what it tells you to do.
Well, my lord, I would also submit that it's a consideration as to whether it's appropriate or not in the first place. Because if you perceive that the hardship is a lack of accommodation, is it not appropriate for the English court to make an order? Why do you have to wait to the Section 18 stage? Why can't you consider it as one of the circumstances in Section 16? I'm not saying it doesn't come into play in Section 18, but it should also be a factor that comes into play in Section 16 as well.
But Section 16 is the gateway to the making of the actual order.
Yes. But it might be justification, or one of the justifications, why an order should be made. Because it directs the court in Section 16, subsection 2, at G, to the availability in England and Wales of any property in respect of which an order under this part of the Act in favour of the applicant could be made. So if you have a wife, as in this case, who says, there is a property here that can be made available to me through the sale proceeds to provide me with a modest flat, and if I don't have that opportunity to buy that flat, I'm going to be homeless here. The only way I can stay here would be to go to the local authority for housing. That, in my submission, should be a factor that should be considered at Section 16.
It might sort of egg the pudding a bit, but I mean, supposing that she was a teacher or something like that, working away perfectly well, it might still be appropriate, having regard to the existence of this property and the absence of an order in Nigeria, to make an order. I can't see why we have only to deal with people who are sort of going to throw themselves on the state.
Well, Lord, I'm just referring to it as a consideration. as a consideration. It's not obviously determinative, and it won't arise in every case, but it could well arise in some cases. I mean, one example I wanted to give was if you had an English wife, let's say, with 3 young children, who were living in rented accommodation in England, but who was divorced abroad in the appropriate forum, and that she couldn't make an application for an order here on the Court of Appeal test. And let's say the foreign court had only made, applying a separation of property regime, had not made any order in respect of the valuable investment property that the husband had here. Is the court to ignore the fact that she may have to claim benefits when the husband's getting valuable income from a rented property?
I mean, I just have this feeling that this Section 16 is concerned with the position as between the parties. And I mean, you say it's the parties, it focuses on the parties. And
yes.
I mean, you then say, well, it's a good idea from the point of view of the British state that we should, and I think that's a slightly different thing. If the Law Commission had wanted to put that in, fair enough, but I just sort of feel that that's not what this is about. It's
going
between
too far.
the two. Mm. It's really, it's circumstances of the parties as between them, whether it's, rather than, it's not here as a sort of provisional wing of the Department of Social Security to sort of, to bring things.
Yes, but Lord, we would say it's still a public policy consideration. It may not be in the language of the statute, but it's a public policy consideration. I mean, it's well known in ancillary relief law, the domestic law here, that the court will not permit, if there are the means available, a party to go on state benefits as a matter of public policy.
But that's the species of order that is made, rather than whether an order should be made at all, isn't it?
Well, it's a consideration, my Lord. It's a consideration as a matter of policy.
But does it not fit more comfortably with Section 18 rather than Section 16? As my Lord Roger points out, Section 16 focuses the attention on the parties, the connection that they have, the availability of property and so on. That's if you like, a concentration on their condition. Section 18, once you've decided that an order should be made, Section 18 arguably widens the debate and other matters can be taken into account in deciding what is the appropriate order now that we have concluded that one should be made.
My Lord, I would just rely on the first part of Section 16, which says, before making an order for financial relief, the court shall consider whether in all the circumstances of the case.
You don't need to reject the suggestions that are being made to you unless you are afraid that they're motivated by a desire to impose upon Section 16 very restrictive grounds of getting over the threshold. Yes. Otherwise, you embrace them with open arms.
Yes. Can I move on? You will have had the impression that these Part 3 applications are solely confined to applications by applicants. But actually Part 3 can be indirectly utilised by a foreign jurisdiction. And a good example of that is a first instance case that I was involved in from this jurisdiction that took place in California earlier this year in San Francisco. And you'll find that at the back of the Authorities Bundle, Volume 2. It's not referred to in our reported case. It's the last tab 32. It's a judgment given at first instance in the Superior Court of the State of California, County of San Francisco, and the judge was Superior Court Judge Anne Christine Mersulo. And the brief facts are that the parties had been married for 18 years. The wife was American, the husband was English. They spent the first 8 years of their married life in England, and the next 10 years were spent in California. The American wife brought proceedings in the Californian court, seeking a distribution of property orders against the husband. And one of the significant assets in the case is that the husband had pension funds in England worth just under £1 million. And the Californian judge considered it was appropriate for the wife to have a share of those funds. And in terms of jurisdiction of the Californian court, it could make orders in personam against the husband to take certain steps with regards to his pension, but it could not make any direct orders against the pension fund managers in England. And if you turn to the last page of the report, of the judgment, page 24, the judge referred to part 3. She said, should husband fail to obey the orders contained herein, wife may apply to the English court for leave under part 3 of the English Matrimonial and Family Proceedings Act 1984 to seek a pension sharing order in England, comporting with this court's orders. Although the above orders do not compel action by the trustees or managers of the respective pension schemes, the court has entered the orders with the expectation that if enforcement is necessary, the English court will in effect enforce the orders in the interests of comity under Part 3 of the English Matrimonial and Family Proceedings Act 1984, if husband is domiciled in England. So this is a good example of what we would say is the evolving nature of Part 3. You can actually have a foreign court recognising that it doesn't have the requisite powers to make the orders it wants, and therefore it relies on the English court to enforce its orders through invoking the powers under Part 3. This is an example of a pension sharing order. Another example could well be where there is immovable property in this country which the foreign court does not have power to deal with.
Yes, we'll adjourn until 2 o'clock.